Welcome to day 7 of our 2026 Bootcamp series. Today's workout session is covering medical fee dispute resolution. Navigating billing disputes can feel a lot like facing this climbing wall, where bottlenecks can entirely halt your office's operational progress. Today, you'll gain the regulatory leverage, the statutory framework, and the structural footing necessary to systematically move past these hurdles, clearing your backlog and conquering the wall efficiently. Let's look at what we're going to get accomplished today. As you can see on the slide, we have 3 core learning objectives today. First, you'll need to know the timeframes to file a medical fee dispute resolution. This ensures your paperwork stays within the deadlines and does not get timed out. Second, you must understand what types of disputes can be resolved by MFDR. This step ensures that you don't waste energy climbing up the wrong wall. And third, you must understand what happens before you file for MFDR. This is where we will secure your footing and anchor your case in the mandatory pre-filing requirements. By mastering these 3 simple points, you'll have a reliable structure to scale this process efficiently every single time. And whether you're joining us for this live broadcast or watching the recording later, the information that is provided is accurate as of June 30th, 2026. While our goal is to educate, the responsibility ultimately falls on you to stay compliant with the Texas Insurance Code, the Texas Labor Code, and the Texas Administrative Code. In the event of a conflict, whether it's a formal dispute or a complaint, the written statutes and rules will always prevail over this presentation. We want our participants to be self-sufficient and highly capable, and so my hope is that you will use all of the tools we provide so that you can educate yourselves and strengthen your foundation. In today's presentation, we'll be learning what is a medical fee dispute, the issues that are not addressed by MFDR, filing requirements, frequently asked questions, and how to find MFDR decisions. Okay, so let's begin with what is a medical fee dispute. Mapping your route correctly from the very beginning ensures your resolution stays on track. Before you take your first step towards resolving any issue, you must choose the correct path. To protect your staff's time and avoid unnecessary delays, you must first know the exact difference between a dispute and a complaint. Think of a dispute as a roadblock on your path to reimbursement. Formally, a dispute is a disagreement between system participants involving entitlement to workers' compensation benefit. There are 3 specific roadblocks or disputes that you will encounter. First are SURL disputes. This is when the insurance carrier disputes the compensability, the extent of injury, the relatedness, or liability of the claim. I will be using the acronym SURL throughout the presentation because it's much shorter and easier to track. Second are medical necessity disputes. This occurs when the insurance carrier disputes the necessity of the health care that you have already provided and billed, or when pre-authorization is denied for health care that has not yet been rendered. And third are fee disputes. This is a direct disagreement over the reimbursement amount of a medical bill. So you should not be filing a complaint on any of these issues. If the carrier challenges SURL, medical necessity, or the bill amount, you're facing a dispute. Now let's look at the other path, the administrative complaint. An administrative complaint is triggered when a system participant violates regulatory mandates. For example, if an insurance carrier fails to adhere to statutory payment timelines, or if a provider improperly bills an injured employee, these constitute direct rule violations. It's critical to note that these infractions are not handled through the medical fee dispute process. Instead, they must be routed to audits and investigations for further compliance review. If you do need to file a complaint, it is critical to rely on the law. This means identifying the exact sections of the Texas Administrative Code or the Texas Labor Code that you believe the carrier did not follow. For example, instead of stating, "I was paid late," a better high-impact statement sounds more like, "The carrier violated 28 Tax Section 133.240 by failing to take final action on the medical bill within the mandatory 45-day window." Providing these exact regulatory coordinates gives the reviewer the necessary language to instantly verify the violation. And you can download the DWC Form 154 in English or in Spanish and send it to the division by one of the methods listed on this slide here. Okay, so back to disputes. Before you begin the process of a medical fee dispute resolution, you must first verify that you are legally permitted to use this specific route. MFDR maintains strict jurisdictional boundary where its primary territory is non-network healthcare. But you might be wondering, can a network claim ever cross into the MFDR process? And yes, only under highly restrictive documented exceptions. And those include an emergency, meaning a true emergency care was rendered by an out-of-network provider, or through a written clearance, which refers to expressly authorized out-of-network care. And as the name says, you must have this secured in writing. Now let's look at the specific paths that legally lead to medical fee dispute resolution. First, MFDR rules apply to non-network healthcare services. This means that if the injured employee has a non-network claim and there is a dispute about payment for the services they received, this dispute can be formally addressed by MFDR. Second, MFDR applies to out-of-network healthcare services that were expressly approved by the network. This means the injured employee's claim is out of network. They received prior approval to obtain treatment or services from a non-network provider. That non-network provider may file an MFDR if there is a dispute over payment for medically necessary treatment of a compensable injury. Third, MFDR rules apply to certain emergency healthcare services. To qualify, these services must meet the definition of an emergency found in Rule Section 133.2, or a life-threatening condition as defined in Section 133.305. Finally, MFDR applies to workers' compensation-specific exams. These include designated doctor exams, required medical exams, and referred doctor MMI and IR rating exams, and treating doctor IR exams. These specific evaluations are not subject to network discounts. Now that we know which paths lead to medical fee dispute resolution, let's take a look at who is permitted to access this process. Rule 133.307 defines who can request an MFDR, and requesters could be healthcare practitioners in hospitals, ambulatory surgical centers, designated doctors, pharmacies and pharmacy processing agents, durable medical equipment providers and suppliers, or the injured employee themselves could also file a request. Now let's review the terrain of common fee-related payment reductions and denials. These will be the typical administrative reasons you might file a medical fee dispute resolution on a non-network bill. Keep in mind, none of these relate to SURL or medical necessity. The first common issue is missing your 95-day deadline to submit a medical bill. If the carrier denies payment for timely filing, the burden of proof is on you. You must provide clear documentation showing that you either met that 95-day deadline or that you've qualified for a specific regulatory exemption. The second area involves evaluation and management office visits. This occurs when an insurance carrier attempts to downcode the service or challenges documentation claiming it does not support the level of services billed. As we know, E&M documentation standards rely on CPT codes chosen by the time spent or by the medical decision making. Because the burden of proof in MFDR is always on the requester, you must prove that your documentation fully supports the CPT definition based on that time or MDM. For more information, you can visit cms.gov or you can view our educational video on the web, the links to which are available on this slide. Our third scenario is fair and reasonable reimbursement, which applies if a service lacks a specific fee guideline or a negotiated contract. If you submit an MFDR request simply demanding a dollar amount without explaining why it meets the statutory definition of fair and reasonable, you will have a very hard time prevailing. You must explicitly justify your math using regulatory guidelines. And finally, you may face an administrative denial if you fail to secure a required pre-authorization. MFDR will not perform a retrospective review of medical necessity here. Instead, the review focuses on the facts of the defense presented by the carrier. Did the service require pre-authorization, and did you obtain it? Now that we have covered what falls within our jurisdiction, I will go over the specific issues or denials that are not addressed through MFDR. So let's look at the next slide to break down these non-MFDR issues one by one. Here's your first example of where a medical bill has been denied and does not belong in MFDR. All medical services can be reviewed for medical necessity by the insurance carrier. They are either reviewed upfront during any required pre-authorization or retrospectively for those services that do not require pre-authorization. This occurs when the carrier conducts a utilization review after services were provided and states on an explanation of benefits that the services have been found to not be medically necessary. An example of this might be office visits, which do not require pre-authorization. Carriers have both the right and the responsibility to review for medical necessity. However, these specific denials cannot be handled through MFDR. They belong in the Independent Review Organization, or IRO, process after you have completed the reconsideration phase. This applies to both network and non-network denials relating to medical necessity. Now, there are two very critical exceptions to this rule where a medical necessity could go through the MFDR process. The first exception applies to services that required pre-authorization. You obtain that pre-authorization and the carrier still issued a retrospective denial for medical necessity. The carrier doesn't get to claim that the service was not medically necessary once they've already approved it through the pre-authorization process. If a claim was denied in this way, you can request reconsideration and reference the language found in Rule 133.240. The second exception involves medical bills generated for a designated doctor exam and any related medical bills under Rule 127.10. These specific bills are not reviewed for medical necessity or SURL, and they can be processed through the MFDR. Knowing these exact boundaries keeps your billing disputes moving down the correct path. Our second example involves any medical bill, except for those designated doctor exams, that is denied for SURL. This type of issue is not a fee dispute. This is an indemnity dispute based on either the compensability, the extent of the injury, relatedness, or liability. These issues need to be resolved in the DWC benefit dispute resolution process. That means going through a benefit review conference or a contested case hearing. It's very important to note that this does not mean you bill the patient and pursue a private claim. You need final adjudication before you can take any action like that, or you risk violating Texas Labor Code 413.042. Another example involves disputes where the claim you are treating is a network claim and you are a contracted provider within that network. About 50% of all new injuries are network claims. So these are either certified workers' compensation healthcare networks or those that are 504 political subdivisions that operate like a network. For these, you will want to contact the network for instructions on how and where to submit your formal complaint or review your contract because it is required to have the network complaint process within it. Which leads me to my next example of what is not handled in MFDR when there is a fee dispute involving a political subdivision employer. These political subdivisions can operate like a network, or they can have direct contracts with their healthcare providers. Because of this, these disputes cannot be handled in MFDR. Instead, they need to go through the political subdivision's complaint process because there's a private contract involved that we at DWC don't have jurisdiction over. Additional information regarding political subdivisions can be found in Labor Code Chapter 504 at the link provided on this slide. DWC does not have jurisdiction over federal claims. Our laws and rules do not apply to federal employers like the IRS, Border Patrol, FBI, or the Post Office. So if you have a denial or a question about those types of claims, the Department of Labor would be the best place to resolve those issues. Next is when you choose to bill an employer directly. As Rule 133.20 states, you can choose to bill a willing employer if they are a subscriber to workers' comp insurance. During that time, you are billing the employer. This is called the election period. However, it is critical to know that if you bill the employer and they partially pay you, ignore you, or refuse to pay you, you cannot seek relief from MFDR. To protect your path to reimbursement, you would need to terminate your election to bill the employer, pivot, and submit the medical bill directly to the insurance carrier. That bill must then hit the insurance carrier's desk on time, which means within the 95 days from the date of service, because if you miss that 95-day window, your billing claim could be denied for denying timely filing, and MFDR may uphold that denial. So you could only access MFDR if you bill the carrier within that 95-day window, receive a payment that you disagree with or are unsatisfied with, or no payment at all, and then you would formally go through the reconsideration process. But now let's look at the other side of the fence for non-subscribers, meaning employers who have opted out of the workers' comp system entirely. If an employer is a non-subscriber, the DWC has absolutely zero jurisdiction over them. Your options are strictly external. You must work by negotiating with the employer directly or choose civil court. We can't provide legal advice on what you must do to resolve any non-subscriber issues. Now let's move into the specific filing requirements. Before we look at the actual paperwork forms, we have to look at the required order of operations. So let's look at the next slide, and we're going to break down the proper dispute sequence. When we talk about filing requirements, the absolute first step on your checklist must be to verify your dispute sequence. Before you fill out a single piece of paper, you should look at the type of denial to ensure that you are on the right track. Generally speaking, if you have a denial about sural or medical necessity, you do not have a fee dispute yet. Think of it as an order of operations. Sural and medical necessity disputes must be handled first, and then after the carrier reprocesses the medical bill according to that final adjudication, if applicable, and all other remaining payment issues would fall under the fee dispute. Just note, as we discussed earlier, there's always unique exceptions to this rule. To further clarify that sequence, you would only have a true fee dispute if a very specific chain of events occurs. First, a final decision must be issued that establishes the care is medically necessary for compensable injury. Next, that bill is reprocessed by the carrier according to a final adjudication, and another EOB is issued. Or if you haven't received an EOB within the 45-day time frame, At that time, if you are dissatisfied with the outcome, you may have a fee dispute. Now, the reality is that most insurance carriers process standard medical bills accurately. The two biggest hurdles you will face on your path are usually thorough or medical necessity, and only a small fraction of the bills truly end up as a fee dispute. But when it does happen, you have a couple of paths available depending on your network status. You would either use MFDR or the network's dispute complaint process. It just depends whether the claim is in network and if you are a part of that network. On this slide, we're providing you with an infographic complete with hyperlinks to help guide you on the correct dispute path. We have mapped out some of the most common denial reasons seen on EOBs, along with the appropriate dispute process to pursue and the exact form you would need to submit to resolve those issues. When you're looking at your paperwork, you'll want to look closely at both of your EOB denial reasons to determine which specific path you need to take. As you look at this chart, remember that most of these processes have deadlines to submit a dispute. You must make absolutely sure that you are pursuing the correct process for your specific denial reason and your specific claim type, which would be either network or non-network. If you do not check this chart and you accidentally file your dispute through an inappropriate process, that mistake is not an exception for missing any other deadline. Filing incorrectly will not pause the clock, and you could completely lose your right to pursue the correct dispute process. Use this infographic to keep your claims on time and on the right track. Now let's discuss 3 essential things to do before you file for MFDR. Step number 1 is reviewing your initial documentation. You need to thoroughly read your initial explanation of benefits, reduction or denial reasons. This review should include the claims adjustment reason codes, as well as any other narrative explanation provided by the insurance carrier. To help your staff decipher these responses, you can find a complete list of the adjustment reason codes at the link provided on this slide. Analyzing these codes carefully ensures you understand exactly why the carrier reduced or denied the payment before you go on to your next step. Step number 2 is the mandatory reconsideration phase. You must request a formal reconsideration of the denied medical bill prior to filing an MFDR request. As you navigate this requirement, remember that you must wait until the insurance carrier takes final action on that medical bill. And in the workers' comp system, final action means that the carrier has formally issued an EOB, or a full 50 days have passed since you submitted your complete medical bill and no EOB was received. Also, keep in mind that if no EOB was received, you must provide convincing evidence proving a medical bill was submitted and that reconsideration was requested. Furthermore, you must keep a close eye on the calendar. Your request for reconsideration must be filed with the insurance carrier within 10 months from the date of service. Continuing with step number 2, once you submit that reconsideration, the insurance carrier has exactly 30 days to process that request. After 30 days have passed from the date you submitted your reconsideration bill, whether the carrier issued an EOB or not, you may formally file an MFDR request if you are unsatisfied with the carrier's final action. So healthcare providers, you will want to keep meticulous records of both your initial and your reconsideration bill submissions because you as the requester always hold the legal burden of proof, remember. It's very important to document every step because you will absolutely need that proof when you file your MFDR request, especially in the event that an EOB was not received. And to ensure that your reconsideration request is valid, you must directly reference the original bill. This means it should have all of the exact same billing codes, the dates of service, and dollar amounts. If not, the insurance carrier could consider it a completely new bill. And if it's sent to them after the 95 days, they could then deny it as untimely filing. The reconsideration request also needs to contain a copy of the original EOB or those convincing documents supporting your attempts to obtain that EOB, any documentation that was not previously submitted, and any convincing documentation supporting the request of the disputed fee amount. Finally, let's look at step number 3. After you file reconsideration, you should receive a second EOB. Once it arrives, you will need to carefully review the ANSI codes and the carrier's explanation for the reduction or denial. This review is incredibly important because this denial reason, or because the denial reasons on both of your EOBs that you've received, assuming that you've received them, will dictate your next move. If the claim is non-network, those combined reasons will determine which specific dispute path you will pursue in DWC. If the claim is in-network, you must stop and check your status. Do not file for MFDR unless you were a healthcare provider who was expressly approved to treat the injured employee as an out-of-network provider, or if you are an out-of-network provider who provided emergency treatment to an injured employee with a network claim. If those specific out-of-network exceptions do not apply to you, the claim you are disputing is in-network. You would need to follow the network's internal complaint process. Next, let's go over the filing deadlines for MFDR. These mandatory deadlines can be found in Rule Section 133.307, which states that you have exactly 1 year from the date of service to file an MFDR, and for inpatient stays, it is 1 year from the date of discharge date, not the admission date. There are 3 distinct exceptions to this 1-year rule, and those exceptions are the first being 60 days after receiving a final adjudication of a several dispute. The carrier will reprocess according to that final adjudication and issue the EOB. If the EOB at that time is unsatisfactory, you may have a fee dispute. Second is 60 days after you receive a final resolution of a medical necessity dispute. And third is 60 days after the receipt of a carrier refund notice. And here you can see Section 133.260 for more information on refunds, and Amy will post a link in the chat where you can find more information on refunds. Finally, rules state that the disputes shall be considered filed on the exact date that the DWC receives the request. Ensuring your package reaches our office before the clock runs out is critical to keeping your dispute active. To formally request a medical fee dispute resolution, your team would need to submit Form DWC 060. When preparing the paperwork, you'll need to complete all of the sections with the exact information it asks for. Again, making sure you list all of the specific dates of service that you're disputing, the CPT codes, the amount you were originally billed, the amount the insurance carrier actually paid, and the amount that is currently in dispute. If you're dealing with a larger claim, don't worry about running out of room on the paperwork. Once you download the form, it will automatically include an extra page for the table of disputed services to give your staff more space if you have more than, say, 10 dates of service to dispute. Here on the slide is a picture of the instructions for the DWC 60 and some FAQs. When you download the form from our website, there will be a total of 4 pages. The actual form takes up the first 2 pages. The instructions and FAQs are in the last 2 pages, and I highly recommend that your staff review these pages carefully before submitting that request. Using these built-in instructions is the best way to ensure that your paperwork is completed correctly the very first time. And there are several ways for you to file your request and your supporting documentation. One way is to mail in your complete packet to the first address that you see listed on this slide. The second way is to personally deliver your packet to DWC at the physical address seen here on the slide. And whichever of these paths you choose, just make sure your delivery timeline accounts for the receipt date at our office to keep your dispute on track. Another method is to send the initial submission of your MFDR electronically by Secure File Transfer Protocol. And here you would just have to name your file that MFDR DWC 060 request. And you would send it to the encrypted email on this slide or by faxing it to the number also provided here. To set up an SFTP, you would send an email to the email address shown here, or you can go to DWC e-filing website for more information. Coming soon, near the end of October, there will be another digital path to submit an MFDR. This system is tailored to the distinct roles of the requesters and the respondents. And once it's live, both will be able to set up a profile directly within TextComp. And from there, MFDR requesters can complete DWC Form 060 and instantly upload any supporting documentations and then handle any subsequent DWC inquiries. Respondents will also be able to submit their formal responses and upload any supporting documentation directly as well. Requesters and respondents will also be able to view the real-time status and status updates of an active dispute. And we would love to ensure a smooth transition, so a comprehensive training will be provided to everyone prior to the official launch date. When submitting your DWC 60 form, your team must ensure that your final packet is complete and accurate. First, your documentation must match perfectly. Again, this means you must list the exact same billing codes, the exact same dates of service, and all of the exact same dollar amounts. Second, you'll want to include a copy of the explanation of benefits or your documents for formal request for an EOB. Make sure your submission includes both the original EOB and the reconsideration EOB. And finally, you must include a clear copy of all the related medical records supporting the services in question. Continuing with our submission checklist, when submitting the DWC 60 form, you must also be sure to include the reasons why you believe the disputed fees should be paid or refunded. Your paperwork needs to state exactly how the labor code and DWC rules, including any specific fee guideline, impacts the disputed fee amount. You must also explain precisely how the medical documentation that you're submitting supports each of those individual issues that are in dispute. Now let's address what happens when a healthcare provider does not receive an EOB from the carrier. This is where you will want to state exactly how and when you requested the EOBs to be sent to you, aka you want proof you submitted your bill to the carrier. You'll want to know who you spoke to and exactly what they said. Document and provide as much information as possible so that the reviewer of your request knows exactly why you had to request a reconsideration without an EOB and why it was not included in the submission. Remember, the burden of proof is always on the requester. For more detailed information, the more detailed information you provide in your position statement and supporting documentation is always for the best. You should also include a copy of the final decision regarding SERL if applicable. This means that a contested case hearing decision ideally addresses the specific dates of the service, the treatments or services provided, and any diagnosis that was denied for SERL on the EOB. And please be sure to carefully follow the instructions and requirements we have covered here today. Skipping a step or messing up the sequence or missing a deadline means your request may be denied entirely. We have a what to expect from medical fee dispute resolution guide. It's outlining dispute types, filing procedures, and potential outcomes. I will demonstrate how to locate that document on our website. So I'm just pulling up the DWC website here, and that's at www.tdi.texas.gov/wc/index.html. I'm going to make sure I'm on the workers' compensation tab, this yellow one here. I'm going to scroll down to our use workers' compensation A through Z. Then I will select M for medical fee dispute resolution. When I scroll down under resources, I can find the link to the what to expect from medical fee dispute resolution. Again, this guide is outlining different dispute types, filing procedures, and then potential outcomes for you as well. Now we'll go over our most frequently answered questions at Comp Connection. How will I know if the DWC received my DWC 060 request? An automated letter will be sent to the address the requester put on the form and will contain an MFDR tracking number assigned to that specific dispute. I want to discuss my medical fee dispute with the person assigned to my case. Is that possible? Unfortunately, the dispute resolution officers are prohibited from direct contact with either party involved in the dispute. I disagree with the insurance carrier's response. Can I send a rebuttal or more information? That answer is yes, of course. You can send additional information to the insurance carrier and to MFDR. And although there is no time frame for you to do so, you would want to send it ASAP, or it may not be considered within the reviewing time. How can I check the status of my medical fee dispute? You would need to send an email to the address shown here and be sure to include the MFDR tracking number. How will I know when my medical fee dispute is resolved? DWC will send the requester an MFDR decision letter via certified mail. Can I appeal a medical fee dispute decision? Yes, you would submit a request to schedule a benefit review conference. This is done by submitting the DWC 045M form within 20 days from when you received the MFDR decision. Can I appeal a medical fee dispute dismissal? No, but you can correct the problem and then file a new dispute. So for example, if you filed a DWC 60 with EOBs that contained a SURL denial, but you didn't include the copy of the final adjudication decision, your request will most likely be dismissed. So when you resubmit, you would want to resubmit the request in its entirety, including the final adjudication decision within the dispute filing deadlines. What do I do if I receive payment from the insurance carrier after I filed a medical fee dispute? If you receive payment, you would let DWC know to withdraw your request by sending an email or a fax. We just ask that you also include the MFDR tracking number for us. How long does dispute resolution take? So while there are no timeframes specified in the workers' comp rules or statutes, typically disputes are resolved within 90 days. It just may take longer if the issue is new or more complex, or if it's under litigation. Did I file a dispute or a complaint? And this is one that we talked about earlier. Complaints are for more so for like rule violations, where disputes are for workers' comp payments. But if you are still unsure, give us a call at Comp Connection. Just have both of your EOBs available at that time of your call so that we can go over those denial reasons with you. Next, I'm going to show you a couple ways that you can search for previously decided MFDR cases. And while this tool is not a guarantee of any type of outcome, it is a helpful research tool to use when putting together an MFDR, as it might provide some insight on the outcome of a similar previously resolved request. All right, so in this database, you're going to find disputes from the current day, and they go all the way back to 2014. The decisions in the table can be filtered, sorted, and exported. And if you don't want to use the table, another way to find previously decided decisions is to Google search by topic or keyword. Okay, so to find this tool, you'll go to your map, to the DWC topics A through Z, and then select M for medical fee dispute decisions. You will see this table of MFDR decisions that have been previously decided on by law. DWC is required to redact and then post those decisions. With this decision search tool, you can filter, sort, and export by the tracking number, the date received, the date issued, the requester, or the insurance name. Alternatively, you can use this Google search. You would have to enter this site exactly as seen on your screen, and then the topic or the keywords, as you can see here as well. For example, if you want to read decisions where the dispute was over timely filing, you would enter timely filing after the metacases semicolon, and Google would search and pull up the different decisions made about timely filing, as you can see here. Now we'll review what we have learned today. We've learned what exactly a medical fee dispute is. We've learned issues that are not addressed by MFDR. We've learned how to file and what you're required to submit along with your dispute. And top 10 frequently asked questions for fee dispute, and how to find MFDR decisions using our search tools. Next, we've prepared a few questions based on today's trek to see who was paying attention to the trail signs. Number 1, we have generally a healthcare provider has 1 year from the date of service or the date of discharge, if it's inpatient, to request the medical fee dispute resolution. That answer is true. Very good. Number 2, the medical bills, generally medical bills denied for extent of injury or relatedness should be submitted to medical fee dispute resolution on a DWC 16. That answer is false. Number 2 is false. What must a healthcare provider do before they file for medical fee dispute resolution? And the answer to that one is all of the above. They should request reconsideration within those 10 months. They should resolve denials for compensability, extent of injury, and relatedness. If the healthcare provider's fee dispute involves fair and reasonable reimbursement, they should ask for their billed charges with no explanation why their charges are fair and reasonable. And that is false. Lastly, a network healthcare provider should submit a workers' compensation certified network fee dispute to the network complaint process, not MFDR, and that is absolutely true. Very good. All right, so we are going to conclude our obstacle course during the next session with instructor Andrea, and she will be discussing return to work and the return to work status report. Our learning objectives for the next session are going to be to know the benefits of recovering while on the job and reducing medically unnecessary time away from the job. You're going to know how to complete and understand the work status report and know the rule that addresses the return to work in that form. If you still have any questions, please call us at Comp Connection, or you can send us an email, compconnection@tdi.texas.gov. And we thank you all for joining us today.